stand only to the mic, just stand normally and talk. This mic will pick you up. Right? When you finish talking, switch off. Turn it on there. Okay.
to start? Okay. Greetings, ladies and gentlemen. My name is Esetu Shezi, the Secretary of the Black Lawyers Association Student Chapter at Pietermaritzburg campus. So I will read through the program and then I will go on. So at first, I will be the program director. And also I will be doing the welcoming address. And then our research of PLA NEC, Mr. Vumani Mtembu, will be doing the introduction. And then we have Nhlakanipo Ngema, who will be doing the introduction for ourselves. And then we have the Moot one, where it will be Puleng and Men's are in, or Puleng faces Men's are in. We have our team, the team of Roberto Brown and Mr. Wandile Matebula, who will be representing Puleng. And we also have Ms. Hlongwana Sandisile and Ms. Mbalenhle Kumalo, who will be representing Men's Are It company. Then the interlude will be delivered. Okay, sorry. So after that, we'll now go through the announcement of the winners and the presentation of awards. And vote of thanks will be done by our chairperson, Nompendro Cele. And after that, there will be refreshment. I greet you all again. As I've said, my name is Esetu Shezi, the Secretary of the PLA. It has been my honor to welcome you all to the first Moot that is hosted by the PLA. So we had our regionals at Pietermaritzburg on the 6th of August, where we saw our participants demonstrating their skills, their analytical skills, and also argumentative skills. It was one of the best moots that we have ever had, because it was our first moot as the PLA SC, Pietermaritzburg. So now, this is the finals. So here we have our two teams. So today we'll know that who are the winners, because we have seen like their very profound skills. They can present the case, they can defend, they can bring super skills, because it's very interesting to see our participants, our students, putting the theory in practice. You know, I always say like everything is much easier when you put it in practice than theorize it. Because you may know something by your head, but can you present it to us? So that is the importance of the mood. This is why like we say as a peer, how about we have a mood for our students, where they get an opportunity like to exhibit their skills. You know, say, oh wow, this is what UKZN has been cooking for us. So I also like to acknowledge our BAC, the chairperson, Nompendro Cele, the PR, Ms. Jomo. Without her, like this would not have happened. Like it's been, from the start, they have been consistent and dedicated. So it was time consuming. And I really, really thank you them for what they have done for us. And to welcome also our judges at large. I welcome you all. It is an honor to have you all here. Before I close, as I've said all that, so I would like us to enjoy and rejoice. And I hope this mood will inspire some ideas to each and every one of us. I thank you. Nice. May we have Mr. Vumani Mtembu on stage.
Good morning, colleagues. As I've just been introduced, my name is Vumani Mtembu. I am a member of the National Executive Committee of the Black Lawyers Association. It is an honor to be part of this special occasion. And on behalf of my president and the entire national executive, they have given me a message to convey to all of you that they congratulate the KZN, UKZN branches, Durban and Pietermaritzburg, for this memorable occasion. They say big things, they always start in KZN. I'm very proud also that I am also from this province, and amongst us, with me, there is a Treasurer General, Mr. Noveni Kubai, who is a member of the National Executive Committee. And I also see that there is also my former chairperson of the formerly known as Durban and Coastal Branch, but it's now known as KZN, Black Lawyers Association Branch. That is Comrade Sfiso Msomi. Welcome, Chief. And I also see that I also have my former secretary of the former branch, which was also known as Durban and Coastal Branch, Comrade Uvigelan Tlogwan. Welcome, Comrade. And I have also noted that there are members of the academic staff present, members of the legal fraternity, and all the judges who will be present, and the participants. Welcome, everyone. In brief, without waste of time, the purpose of this moot court is to move to a different phase, to move to another phase, in a sense that the days of going through the process of being fed with all this theory, and then when we get to the real world, we experience challenges. We want to break that gap. So how can we do that? We can always do that by ensuring that all the students, whilst they are within various institutions, they get an opportunity to exhibit their skills of whatever they have accumulated throughout their years of their academic career. And as you know that this is the first of its kind here in Durban, the approach is that all the branches across the country are being motivated to consider engaging in this exercise, so as to equip all our comrades and young lawyers for the future. And we meet at a very good phase, Comrade Nomdai. We are from Gqeberha. Over the weekend, we had the student chapter annual general meeting where the new leadership was elected. And on behalf of the mother body, NEC, and the entire membership, we want to welcome and congratulate all the members and comrades that have been elected into the new leadership. And I have no doubt that as they will be engaging in their strategic planning in the very near future, amongst other things, this exercise of ensuring that the legal education is taken on a very serious note, this exercise of having these kind of moot courts will be one of the programs which are part of the strategic planning. And I'm sure that as much as we may not be a full house today, but the message will be sent throughout the other branches that it's possible, it's doable, and we will be supporting all the branches. We have committed ourselves as the National Executive Committee to ensure that this program specifically is giving all the support that it needs. So, comrades and all the colleagues, I say for today, all the best. And much as we may have the winner, but the main purpose is to ensure that everyone becomes part and parcel of the exercise. Everyone can be in a position to exhibit those skills. And we're looking forward to have a memorable day with you. Thank you.
Thank you so much, Mr. Mtem. Thank you so much. For now, I would like to introduce Mr. Tlagani Pongema, who is the Deputy Chairperson of the Campus President Respect, who shall now be the Chairperson of the branch of PMP. So, Mr. Tlagani, please.
Rise in court. You can be seated. The University of KwaZulu-Natal Moot Court is now in session. As it pleases the court, may I read the facts of the case. The matter of the case is between Puleng and the Mensa It. Born into a poor family in one of the farming communities of Paddock on the outskirts of KwaZulu-Natal, Puleng's fate was sealed. Most of the children in her community could only go to school up to grade 7 at the local farm school and then start working in the farm. Puleng was thrown in a lifetime when she won all expenses paid for bursary to go to one of the leading boarding schools in the province. Being a bright girl, she excelled in her studies and had her eyes set on securing a place at a university to study law. With the help of the National Financial Scheme Aid, she was able to enroll and complete with the flying colors her BA PPL and the LLB degrees at the University of KwaZulu-Natal. Puleng then secured a Ford Foundation scholarship to study at Harvard University, where she completed a LLM degree majoring in corporate law. Upon her return to South Africa, she then secured her articles of clerkship at Man It firm of attorneys, a law firm based in her home province of KwaZulu-Natal. On its website, Man It prides itself of being a transformed law firm imbued, aligned with the values of the Constitution of South Africa. The website goes on to list some of the clientele of the firm, which list is made up of the A list of corporate South Africa. Man It has been in existence for over 5 decades and has a staff complement of 60 professionals made up of mainly men. The 5 departments within the law firm are all led by men. Given her corporate law training, Puleng, together with the 4 other male recruits, was assigned to corporate law group. Like any other recruit, Puleng was happy to take instructions and to her best to complete the task assigned to her. Within the corporate law group, Puleng became the official minute taker of the group when there were meetings and consultations with clients. The principal would jokingly call her Usiswama Minute, quote, minute-taking lady, unquote, and it becomes her nickname at work. Desperate to impress, Puleng focused on producing top-quality minutes. Her male counterparts were never asked to take minutes. As a tech-savvy person, Puleng makes use of the various digital platforms to network and make friends. On her LinkedIn account, she is linked to her colleagues in the firm, including the senior partners in the firm. A few months into her new job, Puleng received the following posting on her LinkedIn account sent by one of the senior partners known as Bulelani Dambuza. Quote, Puleng, delighted to connect. I appreciate that this is probably politically incorrect, but that is a stunning picture. You definitely win the prize for the best LinkedIn picture I have ever seen. always interested to understand people's skills and how we might work together. Jack, unquote. Puleng finds the comment rather unsettling, and then she tries to read about what the policy of the firm says about harassment and equality. She found that the firm did not have any police. When she tried to raise the issue with Mrs. Van Rooyen, the HR manager, she in turn seized the moment to lecture Puleng on the appropriate dress code and professional for a lawyer at Men Are It. Mrs. Van Rooyen went on to explain that neatness at Men Are It is of the utmost importance and is an aspect of professional conduct. She therefore instructed Puleng to, quote, cut your hair and keep it short so that it looks more tidy, unquote. Puleng feels humiliated and degraded by the implication that her natural African locks are unkempt and must be removed. But she did not cut her hair as instructed. At the end of a 2-year stay at Men Are It, her former colleagues were all given a promotion to be senior associate, and Puleng was not. The feedback given to her was that she needed to grow as a professional, improve on her image, and assimilate the corporate culture at Men Are It. Growing up in a farming community of Pedkop has made Puleng sensitive to injustice and whatever form, and the time spent at Harvard made her to be politically woke. Leaving the situation unchallenged would, in her mind, be tantamount to betrayal, the struggle for justice, and letting the sisterhood down. In the Equality Court in Durban, Puleng argues that the decision by Men Are It not to promote her constitutes an unfair discrimination on the basis of gender and or race, and unfair discrimination in contravention of the sections 6, 7, and or 8 of the Promotion of Equality and Prevention of Unfair Discrimination Act. Further, that the law firm be directed to take steps to have a gender policy that ensures purity of work allocation and equal opportunities for all its employees. Men Are It, on the other hand, argues that the 4 candidates were promoted on merit. The 4 young men, the firm argued, have over 2 years shown their brilliance in articulating themselves during meetings and have clearly made their mark as banding lawyers. Further, for a law firm with such a blue-chip clientele as Men Are It, the firm argues image matters. The University of KwaZulu-Natal Moot Court is deemed to be an appropriate court to exercise its jurisdiction over this matter. Therefore, Puleng is being represented by Mr. Roberto Brown and Mr. Gwandile Matebula. The respondent is represented by Ms. Sandisile Hlongwane and Ms. Mbalenhle Khumalo. Thank you.
In future, before you come to court, you have to formally send your practice note so that we could know who you are and where do you come from, including the Respondents' Council. And now it's your turn, Council. Tell us why you are here.
As it pleases the court, I am Roberto Brown, and together with my co-counsel Gwandile Matebula appear on behalf of the applicant Puleng. Thank you.
As it pleases the court, my name is Sandisile Shongwane, and I go with my co-counsel, which is Mbalenje Kumalo, who will be representing the respondent side according to the heads of arguments.
Thank you, Justice. Justices,
All right, thank you. I'm reminded to always be on record.
Thank you, Justice.
Applicant's counsel, now is your turn.
Okay, thank you, Justice. Justices, shall it please the court, I'm appearing on behalf of the applicants Buleng, and to unpack and submit our heads of arguments, we will deal with 3 issues. I will be dealing with the first issue, and my co-counsel will be dealing with the second and the last issue.
I can assure you that I've read the heads.
Thank you, Justice.
Thank you.
I will be consuming 15 minutes of our allocated time, and my co-counsel will be consuming the other 15 minutes. Now, Justices, to unpack the first issue, I'll divide it into 2. I'll first deal with harassment based on the grounds of race and harassment based on the ground of gender. If it pleases the court, our Constitution states from its preamble that it recognizes the injustices of our past, and it is, according to Section 1, subsection A, grounded and founded based on the founding values of non-sexism and non-racism, and it is off to promote equality to the citizens. Thus, the Constitution prescribes under Section 9 that everyone is entitled to equality, and further to indicate the prohibited grounds of discrimination under Section 9, subsection 3, subsection 4, whereby racism and gender and sex are also included as the prohibited grounds of discrimination. To further put Section 9 of the Constitution, the legislature has implemented the Employment Equity Act to apply Section 9 provisions to the employment environment. The Employment Equity Act was implemented with the objectives to promote equality and equity to the employees on the employment ground. Justices, it is our reality in South Africa that racism is the monster in our society.
Let me get you clear so that I should not be lost. Is your case based on the Section 9 of the Constitution or
Justices,
Section 6 of the Employment Equity Act?
Thank you, Justice. Our case is based on Section 6 of the Employment Equity Act, which also put into place the provision from Section 9 of the Constitution to the work or employment environment.
Thank you.
Yeah, thank you, Justice. Now, to further provide our heads of argument, the Employment Equity Act has the objectives to promote equality and equity on workplace. As Section 6, subsection 1 of the Employment Equity Act provides that unfair discrimination, either directly or indirectly, is prohibited based on the prohibited grounds of gender, equality, race and sex, and other grounds that are also indicated from Section 9 of the Constitution. Furthermore, Section 6, subsection 4 of the Employment Equity Act indicates that harassment on the employment environment is prohibited and is deemed as of discrimination. To put into place the effectivity of the Employment Equity Act objectives, Section 6, subsection 4 of the Employment Equity Act indicates that harassment shall be prohibited and shall be dealt with by the employee at workplace. However, Justices, the Employment Equity Act does not define harassment. To put into place the effectivity of the Employment Equity Act, Section 54 of the Employment Equity Act authorizes the implementation of the code of good practice at workplace, which then furthers to define harassment as any conduct that discriminates against employees based on the prohibited grounds that are also indicated under Section 9 of the Constitution.
Council, may I interject? I know with respect to the time. Are you also aware that in the papers of the respondents,
Yes, Justice.
they are saying you are bringing a case that actually did not happen during the, within the workplace vicinities, therefore it cannot be. So I would want you to address me as well on that.
Thank you, Justice, for raising that question. To answer your question, Justice, I'd like to take the court attention to the Campbell or Simmers case, which is indicated under in page 5, paragraph 4.1, 15.4.1. In the Simmers case, the court indicated that to determine whether the harassment or rather discrimination had occurred within the employment practices, the Bartford test shall be employed. The Bartford test queries whether, but for the employment, would have the discrimination occurred. In this case, the discrimination that we submit has occurred upon our applicants was posed on the media platform LinkedIn, whereby the statement was posted by one of the employees of MENA-IT, which are the respondents. Justices, the LinkedIn platform is whereby employees connect. Our applicants connected with the alleged perpetrator as of their employment relationship. If our applicant was not employed by MENA-IT with the person who has posted the statement, then there would have been no statement that is in question today. Therefore, counsel submits that the harassment had occurred within the employment practices as if the employees, including our applicant, Buleng, are employed by MENA-IT and is linked with the person who has posted the statement as a result of their employment relationship, which is based on the MENA-IT as the employees.
The Respondents' Council now comes before us and say
Yes, Justice.
that cannot be enough. And where would you, Ms. Van Rooyen, future here?
Pardon, Justice.
I'm saying with this respondents comes and said, but you are presenting this matter, you want to put this within the workplace.
Yes, Justice.
I'm asking you, where is Ms. Van Rooyen future in this matter? I can see, Council, you have not addressed me on your paper in respect of that.
Thank you, Justice. Ms. Van Rooyen, who is the HR manager and MENA-IT, has performed another harassment based on the ground of gender. The first employee has, the employee, Buleng, who is our applicant, incurred harassment based on the gender of race or on the platform. Therefore, there are two harassment that had occurred.
But my concern is I don't see it in your papers.
The second,
remember, I'm supposed to rule on what is before me. So if
Yes,
I can,
yes.
I don't see it on a paper. So I'm giving you the opportunity to ventilate on that.
Okay, thank you, Justice. Then, Justice, to deal with the second issue that you have raised, I will refer to the Code of Good Conduct, which indicates the test to determine whether there is harassment based on the ground of race and whether there is harassment based on the ground of gender. Ms. Van Rooyen had stated that the applicant shall cut his hair for it to be more tidy as a professional who is employed at MENA-IT. Justices, as it is indicated under the Code of Good Conduct, the race is one of the prohibited grounds that are prohibited by the Constitution and the Employment Equity Act. To determine whether there is race based on the grounds of, there is race discrimination or rather harassment based on the grounds of race, It is outlined under the Code of Good Conduct, the test to determine this issue. First, it shall be stated that race occurs when a person is subjected to a discrimination based on his or her intrinsic characteristic, which is of the race group or ethnic group that the person subject to the discrimination belongs to. Secondly, the conduct or a statement that is alleged to be a racist statement shall be incurring to the applicant's dignity, and it shall be demeaning, and it shall pose a hostile and intimidating workplace for the person subject to. Lastly, the conduct or language should be deemed unwanted by the applicant who is subjected to it based on his subjectivity. To apply the test that is outlined on the Code of Good Conduct, in order for council to deal with the harassment based on the ground of race, council submits that our applicant is an African and Ms. Van Rooyen is of another race. Ms. Van Rooyen views the applicant's intrinsic characteristic, which is the hair, as untidy, implicitly as she indicates that the applicant should cut her hair to be more professional and tidy at workplace.
I can see, Council, that you have taken advantage of that question and trying to put the case out of your out of your heads of argument. But I'll allow you to do that.
Thank you, Justice.
Yes.
Justices, for the harassment based on the grounds of race to be proved, it shall be also proved that the applicant or the person who is subject to that alleged harassment based on the grounds of race, that he or she repudiates or it is an unwanted conduct. Justices, when analyzing the facts, our applicant did not follow the instructions from Ms. Van Rooyen to cut her hair to be more tidy and professional. This implies that our applicant views Ms. Van Rooyen's conduct as being demeaning to her, as it demeans her dignity as an African who has the intrinsic characteristic of having the hair our applicant has. Moreover, it shall be also indicated that to determine whether there is harassment based on the grounds of race, a reasonable person on the grounds of the applicant or the complainant should also take or view the harassment, the conduct, or the statement as constituting true harassment based on the grounds of race. As applicant, the council submits that we should also take into consideration the background and the surrounding factors to determine this test. First, our applicant is from a traditionally based community. It is not in dispute that our rural or traditional based communities are founded on the values of traditional norms. One of our traditional norms includes the principle that women are subject or should submit to men, which is of patriarchal system.
I can see you are reminded that 2 minutes left.
There's 2 minutes.
Right. So cancel.
To then conclude, as to the interest of time, Justices, we submit that the conduct of the respondents constitutes harassment based on the ground of race and furthermore constitutes harassment based on the grounds of gender. Therefore, council submits that the court shall deem the respondent's conduct as of harassment based on the Employment Equity Act under subsection 6, subsection 4. Thank you, Justice.
Thank you, Counsel. Before you sit, I think your 2 minutes is still on.
Okay.
I saw that you are agreeing with me when I said, the issue of Ms. Van Rooyen was not addressed in your head.
Justice,
No, I'm saying I can see that.
Yes.
Did you see the page where you are addressing it?
yeah, there is a page, Justice, under page 9 of my heads of argument.
I wanted you actually to direct me to that when
Yes,
I said I
Justice.
can see that.
Yes.
But thank you very much for
Okay, thanks, Justice.
Okay.
Justices, my name is Kwandile Matsebula, and I'm here dealing with the second issue, whether the employer failed to employ measures to militate the harassment at the workplace. The applicant's concerned that her employer shall be vicariously liable for the harassment she incurred. In terms of Section 60 of the Equity Act, Section 60 of the Equity Act places a duty upon the employer to militate and protect their employees from being subjected to discriminatory grounds at the workplace. Then counsels would like to apply Section 60 of the Equity Act to substantiate that an employer is vicariously liable for the sexual and racial harassment incurred by the applicant. Firstly, looking at Section 60, subsection 1, which provides that an employee who alleges any contravention of the Equity Act's provision by another employee, including unfair discrimination and harassment, which is also the unfair discrimination, that the employee shall immediately put the alleged conduct to the attention of the employer. In the matter at hand,
Counsel,
yes,
I've noticed that you are dealing with the issue of unfair discrimination.
yes,
And I was checking your heads of argument
yes,
because I couldn't see the test in request. I mean, in respect of that, you went immediately and claimed that this is unfair discrimination. I wanted you to address me on how do you arrive at that particular?
how did I?
For a conduct to become of unfair discrimination, it should become in some way.
Yes,
And I was expecting you to save time, address me on the test for that unfair discrimination, if you were to.
for the test for discrimination.
For instance, I know that there must be differentiation before you reach the unfair discrimination. Not so.
I thought my counsel dealt with the test for the discrimination.
No, I'm addressing you.
Yes.
Yes.
Okay.
He didn't. I was waiting for you to address it. Then, do you know the test for unfair discrimination?
Well, my second issue was dealing with the liability of the employer in the
Correct,
workplace.
yes. But
Yes.
for that liability to be there,
Yes,
then you should prove unfair discrimination.
yes,
And before you start by going to unfair discrimination, there must be differentiation also.
yes,
And after that differentiation, then that differentiation should amount to discrimination. And from that discrimination, it should amount to unfair discrimination. And it can only pass the constitutional muster if it's not going to be limited in terms of Section 36 of the Constitution, not so. I wanted to take you that into, so that you should take that into account when you argue there.
okay. To get your
Now, my intention is not to confuse you. My intention is to draw you to that attention when you are arguing this matter.
my justice, as I've already indicated that I'm here to deal with the liability of the employer.
Thank you, thank you.
Yes. In the matter at hand, after alleging that there was harassment on the grounds of gender that has incurred by the applicant reported the matter to the HR manager of the MENA IT firm. A reasonable employee will approach a supervisor or the manager of the employer to report any alleged discriminatory conduct by other employees, as manner it is a juristic person represented by a natural person, including managers. Moving on to section 60, subsection 2, which imposes the duty to enforce reasonable measures. And it entails that the employer shall take necessary measures to redress the matter in question by consulting with the employers in dispute, and if the employer omits taking necessary steps to readdress the alleged conduct brought into the light of the employer, the latter may be vicariously liable for the contended contravention by one of the employees.
Sorry, you referred to the discrimination that hasn't been or has been reported. Is this the gender discrimination that your council has referred to, or is this the race discrimination that your council has responded to?
Okay, my lord, I would like to refer you to my heads of argument, page 14, page 14, 4.2.3.7. As indicated in the fact that bullying 4.2.3.7, page 14. Yes. Bullying raised the harassment on the grounds of race. The HR manager omitted from attempting to take any reasonable measures as required by section 60, subsection 2, or even taking into consideration the matter raised by the applicant. Instead, the HR manager elected to state a statement constituting racial harassment upon the applicant. Therefore, I will also to draw the court's attention to my heads of argument, page 13, 4.2.33. That it is worthy to know that in the case of Bigger versus the city of Johannesburg, the court held that an employer who failed to employ reasonable measures to prevent any contravention of the Equity Act will be vicariously liable if the contravention has occurred as a result of the employment relationship the employer has instituted. Thus, the contravention need not to occur in the actual place. It occur at the commune provided by the employer to the employees. Moreover, in the Liberty Group Limited versus M's case, the court interpreted section 60, subsection 4 of the Equity Act that provides an employer shall take necessary and reasonable practicable measure to readdress and prevent the reported discriminatory contravention. And failure to employ and enforce all practicable measures, an employer would be vicariously liable for the discrimination in conduct. Lastly, it is not in dispute that an employer may be liable for the conduct of the
I did read your heads of argument. What I'm curious about here is you're holding the respondent vicariously liable for the harassment based on race, or vicariously liable for the harassment based on gender, which she reported. So which one did she report, and which one are you holding her liable for, or the respondent liable for?
Okay. Referring the court's attention to my heads of argument, page 14?
Yes, I did see page 14. On page 14, you say that they are raising harassment on the grounds of race, right? So that's what she reported. So you referred us to section 60, right? Yes. Section 60, where your your client reported the issue that there was a gender-based discrimination,
Yes.
right? Whereby what then occurs at that moment, the racial issue. So at this point, which issue did she raise? Did she raise the ground of race, or did she raise the ground of harassment, which she reported in terms of Section 60? Because in Section 60, she must report the issue. So which is it that you are going through right now, Section 61?
As Section 61.
Section 61
Yes.
is when you are referring us to the reporting of the issue to a supervisor
Yes.
or an HR manager. What did she report? The grounds of the grounds of race, or the grounds of sexual harassment or gender? What are you
Okay.
taking us
The
on?
applicant raised the matter with the HR manager regarding the on the ground of sexual harassment, and then the HR manager continued to stating a statement that constitutes a racial harassment now upon the applicant.
Okay.
Yes. Therefore, relying on Section 60, subsection 3 provision that the employer have to be liable for sexual harassment incurred by the applicant. Relying on Baker's case, even if the sexual harassment incurred by applicant occurred on the digital platform, the employer is still liable for the applicant's relationship with the perpetrator is a result of being both employees at MENA IT. Therefore, counsel submits that as MENA IT is a juristic person represented by natural persons, in this case, the HR manager. As the representative of the MENA it failed to take reasonable measures and investigate the race discriminatory conduct. The employer contravened Section 60, subsection 2 of the Equity Act. In conclusion, in this issue, counsel submit that the employer in question failed to employ reasonable measure to militate the harassment incurred by the applicant on employment practices. Thus, the employer shall be held liable as Section 60 was contravened. Moving on, my justices.
Counsel, before you move on.
Yes, my justice.
You have asked us to at least have a prayer. You sought an order for nothing. Have you seen that in your heads of argument?
Okay.
Your prayer is saying, counsel sought the court order that men are in it, employee Bulelani, and they to be vicariously liable for harassment on the ground of gender. And you did not state any in your papers actually what you want.
Okay.
Whether it's compensation.
Okay. I would like to infer the court to page 17 of my head of arguments.
Thank you.
Yes. 4.5. That's our prayer. Now I would like to state the prayer for the second issue, which states that we, as the counsel of the applicants, would like an court order that the MENA IT employee Bulelani Dambuza and the employer MENA IT to be vicariously liable for the harassment on the grounds of gender and race they have subjected the applicant to.
But that still says nothing. You see, the acts provide
Yes.
what can be the remedies, and one of those might be the compensation.
Compensation.
Because this becomes unfair discrimination. I've seen counsel wherein the acts might even provide, the Labor Relations Act, out to 24 months of compensation. But you have said nothing about what the court should order. Actually, you are sorting a declaratory order to say we must just pronounce that the employer failed. And if the employer failed, what follows?
Well, as the my lord, I would like to answer this as a person that who thinks that if a person has been violated on the grounds of race, sexual harassment. As we are suing the employer, we cannot sue the employer on the grounds that we want sympathy. No, we cannot do that. But however, we can hurt the employer where it had the most money. So this our prayer. We are liking to have a court order subjecting the employer to pay damages on behalf on the applicant.
Counsel, if you are amending your papers, you should say so correctly, to say if and is allowed in court before judgment. Yes. If you are saying you need compensation of how much, should we find in your favor?
Yes.
Then you have to say so. Remember, the court cannot assume what actually you want.
Yes. My justices, I cannot confer or saying the exact amount. However, it is our job to describe that, to show the court that our applicant has experienced sexual harassment and also and also the race unfair discrimination by the employer, and the employer has failed to take reasonable steps. We would like to make it the courts obligate, or would like to make the court to rule in favor of the applicant that she was subjected to these grounds.
When we rule, what would you want us to then decide on? So should we just then declare that it's been unfair? And then what? What are you asking us to do is probably what we really want to know. If we do find in your favor, once we do decide that, yes, it's been unfair, then what then happens after that? So it's unfair, but what do you want for your client? What does your client want to happen?
To be compensated.
It's when you ask for the compensation and you let us know, so we will be able to decide on how we can then go forward, should we then decide that, your client, or we find in favor of your client, right?
Yes.
Okay.
Moving on to issue number 3, the employer's failure to promote bullying amounted to unfair labor practice. The crux of the third issue is that the employer's omissions not to promote the applicant constituted unfair labor practice. Thus, the Council outlines the relevant provision to substantiate the submissions. The Labour Relations Act was implemented to complement the constitutional right encompassed by Section 23 of the present Constitution.
Council, I'm reminded of the time that you are above. Can you quickly wrap up?
Okay. If I may ask, how much time do I have? 1 minute.
1 minute, Council.
Okay. I would like to point this court's attention to page, my justices. Okay, to page 15. Page 15. Yes, there are 4.3.5. Section 186, subsection 2A, lists labor practice of promoting employee as one of the possible grounds that this may be conducted unfairly. And then I would like to move the court's attention to now to same page, 4.3.61. The applicant possesses necessary attributes to be promoted by the employer. She has her, firstly, there is no dispute that the applicant possesses the relevant qualification to make her fit.
Counsel,
Yes.
I'm told that your time is up. However, don't feel discouraged. We've read your papers.
Yes. Okay,
Then,
thank you.
obviously.
Thank you.
Actually, I understand you to be saying that there is unfair labor practice
Yes.
in respect of the promotion that should have taken place
Yes,
in favor of your client.
thank you.
Let's call it a day. Thank you very much.
The court is going to adjourn for 10 minutes. Rise in court. The court registrar would like to register his extended apologies on assuming powers of the judge by requesting the court to adjourn instead of the court taking a break of 10 minutes. Now the court is in session. Thank you.
Thank you. Respondents' counsel. Now it's your turn. You may address the court.
Apologies, my lord and ladies. If it may please the court, I and my co-counsel will be representing 2 issues before the court. And the first issue, we state that the claim brought by the applicant in terms of harassment and unfair discrimination in terms of the Employment Equity Act 55 of 1998 goes against with Section 61 of the Act. Then my co-counsel will be dealing with the second issue, of which we argue that the claim failure to promote her does not amount to unfair labor practice as in terms of the Labor Relations Act. If it may please the court, may I now proceed with my head of arguments concerning the first issue?
You can, counsel.
Thank you, my lord. Section 60, subsection 1 of the Employment Equity Act 55 of 1998 outrules the issue of harassment and unfair discrimination goes against the company's parameters. Section 60, subsection 1 of the Employment Equity Act 55 of 1999 outlines the liability of an employer, states that if it is alleged that an employee, while at work, contravened a provision of this act or engaged in any conduct, must immediately be brought to the attention of the employer.
I hope the judge is also having some seconds. I hope my phone is not disturbing the technician, because I'm using it to link on the laptop. Thank you.
The applicant mentioned the case of harassment in terms of how one of the senior members or partners of Mena Ed's company sent a posting to the applicant's profile on her LinkedIn profile. The applicant raised how the comment and posting was unsettling. As a respondent, we acknowledge such claims and we condone no form of harassment against any employee as set out by the Employment Equity Act 55 of 1998. Hence, to address such an issue, it is the respondent's interest to outline the provisions as set out by the preceding subsections of Section 60, subsection 1 of the Employment Equity Act 55 of 1998 as follows. Section 62 of the Employment Equity Act 55 of 1998 states that the employer must consult in all relevant parties and must take the necessary steps to eliminate the alleged conduct and comply with the provisions of the Act. In terms of this subsection, the respondent provides that before analyzing the issue at hand, the issue to be addressed should be in all aspects highlighted by the all external features of the incident in occurrence.
Counsel, may I interrupt you there?
Yes, my lord.
It's very interesting you're quoting Section 62.
Yes,
in this case, the applicant's counsel are saying, yes, there was this publication harassment on this LinkedIn, and Ms. Van Rooyen was part of that. And instead of resolving it, then she started telling the applicant to cut the hair. I would want to address me on that as to whether was those the steps that was taken by the employer to prevent this from happening.
As it may please the court.
Yes.
In my opinion, I feel as if during the incident of wherein the
I must
applicant... Apologies, my lord. Apologies, my lord. According to our papers, we addressed that the issue as set out by the applicant that she was addressed to cut her hair does actually inflict her rights to...
Yes, I understand your concession. Council, relax there. Actually, what I want you to address me on is what did the employer do when it was brought to the attention of the employer that the applicant was harassed?
As it pleased the court, we submitted in our heads of argument on how to deal with such an issue as responded by the applicant.
What was your submission? That is what I attended. It's not your case that this matter happened outside the workplace. Is that your case?
That is my case, my lord.
Yes.
That it happened outside the premises of the workplace.
So you can still take me through that on your case. Remember, I'm not against your argument.
Yes, my lord.
I want to understand whether what they are saying really, do you agree with them that indeed this one was harassment and it was based on race and gender? And whether the basis upon which they rely on you agree with them. Relax on that and agree your matter. Some of the question might be assisting you, some might not, but you still have to answer there.
Thank you, my lord.
Yes.
So for instance, on your heads of arguments, where you've just started, you've just told us that you acknowledge such claims. So do you acknowledge that they happened? Do you acknowledge that they were unfair? You don't condone them? Then what did you do about it upon hearing them?
As it pleased the court, such claims were not unfair. And in our comment, we submit that the respondent should have dealt with the applicant's claim in a different form in terms of violating her rights to race and gender being violated by the provisions and by the act of commenting on your profile. If it may please the court, may I proceed in my head of arguments?
Thank you, counsel. And you are reminded that 10 minutes is left.
Thank you, my lord.
Thank you.
Section 60, subsection 2 of the Employment Equity Act of 1999 states that the employer must consult all the relevant parties and must take the necessary steps to eliminate the alleged conduct and comply with the provisions of the Act. In terms of this subsection, the respondents provide that before analyzing the issue at hand, the issue to be addressed should be in all aspects highlighted in the all external features of the incident occurrence. The first claim is that the LinkedIn incident occurred outside the perimeters of the company's premises and abilities. The colleague in question sent the profile post on the applicant's post at their own expense and personal time, and the applicant responded during her own personal time. The company has no policy regarding against whom the employees should or should not communicate with in all their times during and off work premises. The claim goes along with that both the colleague and the applicant were communicating in their own personal spaces, and the comments of being unsettling should be addressed by the applicant herself aside with the colleague in question during their chat session and resolve the issue at their personal time, since the chat was during their personal time and outside the work parameters of the workplace.
But what is your comment on the fact that this submission, this linkhead, what is your comment on the issue that the linkhead itself is a social platform that has linked the people who are working, in the same workplace, and the other one is senior? How do you comment on that issue?
If it may please the court, we cannot limit her right of having the right to privacy, hence, which the right is not within the right to human dignity. Human dignity is also a derogable right, and we as a respondent submit that if the comments were dealt with during the LinkedIn offense and commenting during take place, that means that obviously her right to privacy would be inflicted. Hence, going through her personal space and personal phone means the company and the respondent itself goes within the parameters of searching her phone and assisting her with a comment that had happened during her personal time and also during her phone space time, and which we submit cannot be dealt with in the work premises of the workplace.
Counsel, I'd like to interrupt you. You keep mentioning that the incident occurred outside of the workplace environment. However, they are both employees. Would you not think that the behavior of a senior partner and the imbalancement of power would overlap into their workplace environments, and that she would be intimidated by him or more susceptible to do what she wants?
If it may please the court, may my lady please reinverse the question in simpler terms.
Would the outside interaction between employees not impact the inside daily interaction between employees? He is also in a position of power. She's an associate or aspiring to be an associate, and he may influence her. Would it not intimidate her in her behavior at work or create an unsafe work environment for her? How has the employer created a safer working environment for the two? Thank you.
Thank you, my lady. If it may please the court, concerning the comments on a LinkedIn profile, the respondent itself deals that we should not interfere in her private issues. Hence, the right to privacy would be inflicted. Hence, the occurrence occurred during the outside the workplace premises, and we should not interfere with such inferences or circumstances. Hence, it was outside the workplace premises. If it may please the court, may I continue with my head of arguments?
Thank you.
Apologies. Okay. If it may please the court, I would like to continue with my heads of arguments as set out by our heads of arguments. If the respondent deals with such acts of banning unsettling comments on the applicant's behalf, then the action would implicate that the applicant allows the company to interfere in a personal workspace and issues, to an extent where the company would themselves provide even a personal assistance for the applicants in terms of texting and communication keeping purposes. The court must keep in mind that such a strategy would assist the applicant in terms of future alike situations of receiving insults via textual communication, and the company's personal assistant assigned for the applicant herself would have to take over the applicant's phone during and after work premises to deal with offensive texters, and also helping her with dealing such offensive texters. That will be impossible, and to the applicant herself would make her feel like her own personal space is invaded. We therefore urge the court to look deep in such circumstances, not that we are disputing the applicant's claim, but the question would be, the court should assist in preventing the misuse of my client's company resources in terms of curbing circumstances of which the applicant herself should deal with her own in her own space, and the respondent does not promote any extramural provisions of such Hence, it is logic that any person could deal with such instances at that given time at their own personal space, unless if the applicant provides any printed or unauthorized, or actually let me just say authorized claims that entails that she cannot deal with her own personal issues aside and needs a personal assistance to attack or to assist in tackling such issues relating to during and off-duty texting and communication queries.
I'm reminded that we are left with 5 minutes.
If it may please the court,
I'm not going to interrupt, but I was going to give directive as to how do you respond to the question that there is a problem with the promotion of excluding the applicant.
if it may please the court, my lord, the question that the court raised, may I ask that it should be addressed by my co-counsel, hence her issue deals with such an issue. If it may please
Thank
the
you,
court.
counsel.
Thank you, my lord. Section 64 concludes that our issue that despite subsection 3, an employer is not liable for the conduct of an employee if the employer proves that it did all that was necessary and reasonable to ensure that the employee should not act in a contravention of this act. The claims made by paragraph 3.3 and 3.4 of our heads of argument outlines as to providing the evidence that the respondent is not at fault, and all claims laid against the respondent should be dismissed. The claims of the applicant being Usesioma minutes also is an issue that should be analyzed by the paragraph set by 3.3 of our paragraphs, and as the conclusion is inter alia as set out by the provisions as set out by section 60 of the Employment Equity Act 55 of 1998. If the court pleases, may I just skim read the case law of such relevant issues. The refound. In the case of Gumete and Crimson Clover, it's a PTY Ltd company of an island hotel, the court held that it did not constitute all that was reasonable and practicable, and the employer was held accountable for the unfair discrimination. The commissioner stated that unfair discrimination and prejudice are evils that must be eradicated from society, and respect for human dignity must be recognized. The applicant was rewarded compensation. However, in the case of Ngwabe and Imvula Quality Protection Pty, of which an LTD company, an employer in a discussion with the MD of the company referred to a co-employee with only one eye as an eye, either to identify him to the MD or possibly as a joke in poor taste. This was found that it is not to constitute unfair discrimination, as the employee has offered an apology and admitted a written warning.
Counsel, your time is becoming limited.
If it may please the court, may I just conclude?
Yes.
In the conclusion of Ngwabe and Mvula Quality Protection case, it was held that even if the terms was a mild form of discrimination, the employer has taken the necessary steps and could therefore not be held liable.
2 minutes.
That concludes my argument for the first issue, and if it may please the court, my co-counsel will proceed with the second issue of our heads of arguments. If it may please the court, may I take my seat? Thank you, my lord.
May it please the court, I will be dealing with the second issue as my co-counsel has mentioned, which is the issue of failure to promote the applicant amounts to unfair labor practice in terms of Section 186, subsection 2 of the Labor Relations Act 66 of 1995. According to Section 186, subsection 2 of the Labor Relations Act 66 of 1995, unfair labor practice means any act that or omission that arises between an employer and employee involving A, unfair conduct by employer to the promotion, demotion, probation, or training of an employee, or relating to the provision of benefits of an employee. We submit that employers are free to choose whom to appoint. They are at liberty to decide which posts to create and who will fill them, and who to appoint for vacancies. The applicant, together with 3 other candidates, were chosen to be part of the corporate group. Men Are It is a firm with an A-list clientele. The applicant has an exceptional resume, hence that's why the respondent hired her to be part of the company. The candidates were all given a fair chance to showcase their abilities in and outside meetings. The respondent chose who to promote based on merits. The applicant may argue that she was only given a task to take minutes in meetings. We submit that
Council,
outside.
I'm aware of the time, but I think the break should stay because this is important. Okay, look, you are saying the employer has a right to choose who he wants. Don't you think that the employer as well has an obligation when he comes before this court to show us as to how that merits were assessed, what criteria was used to find that these 4 men were able to meet the requirement and this female did not meet? Can you address me on that?
My lord, the respondents chose who to promote based on their work ethics in and outside meetings.
Yes. And I was interested to know those ethics.
So the respondent mentioned in the fact that they chose to promote the candidates based on the exceptional work that they showed when they were having meetings.
Council, I would like to interrupt, and I would just like to ask why was only she, as a female, asked to take minutes? Why were her male counterparts not also given that opportunity, or why was she only given that opportunity? How was there equality if only one specific gender was giving attention to it?
Well, my lady, the issue of choosing who will take the minutes was not a matter of gender. She was chosen to take minutes at first, and then we saw that she was doing an exceptional job. So hence, that's why we gave her the job to continue taking minutes in our meetings.
Was that the best use of her capabilities? I mean, she attended a world-renowned university like Harvard. She had a great academic record. So how was minute-taking the best use of her capabilities, would you?
My lady, we recognize that the applicant has, she has obtained some degrees, exceptional degrees, can you please repeat the question?
Was taking minutes the best use of her capabilities? Was it a good opportunity for her because her male counterparts were not asked to do the same? So how is there a level playing field for all candidates if that was the only notable thing that they had given her to do?
Okay, my lady, we recognize that, and we would like to submit that work does not begin and end in meetings. She had an opportunity to show her abilities outside meetings.
Mm-hmm. Was that reflected anywhere else, or was it noted anywhere else by the employer that they had given her other opportunities? Or
in the case, it was mentioned, in the fact, it was mentioned that she, in the facts, what was mentioned is that she was asked to take, by the applicant, is that she was asked to take minutes in meetings. She did not mention if she was given a fair chance outside meetings.
Okay, thank you.
Say when she was asked to take minutes, would it depend as to how long she take that minute? Wouldn't this be that it will also depend on how long has she been taking minutes and whether she acted on the issue of the taking of the minutes? Did she challenge that from the beginning?
My lord, she never challenged that assigning her to taking minutes was. She never mentioned that assigning her to taking minutes was something that she didn't like to do. She took the instructions and gave it her best. If she was not happy, she should have mentioned that taking minutes in meetings is limiting her abilities.
Thank you, Council. You can proceed.
Okay. In the case of Ngane versus Leicester and Owen others, it was clear that when promoting employees, an employer must abide by the law and its clear objective criteria that it has set for the promotion. Eligible employees must have a fair chance to compete for a post. And as I've mentioned, work does not begin and end in meetings. The applicant had an opportunity to show what she was capable of outside meetings.
I'm told 10 minutes left.
Okay. B, unfair suspension of an employer or any disciplinary action short of dismissal in respect of an employee. As a lawyer, how you address and present yourself helps you to present a positive and professional image to others. Looking neat and put together is of paramount importance. A company is entitled to its own dress code policy, which conveys an employee's attire should reflect the culture of the organization, and employees should follow company policy. When you sign a contract of employment, you are abiding yourself to all company policies. Mrs. Van is responsible for such matters as she is HR. It is in her discretion to determine if the way you present yourself upholds company policy, and if it upholds.
Hi, Council. Sorry. Oh, you can. You mentioned, or your councillor or your colleague mentioned earlier that they acknowledged that what Ms. Van Rooyen has said was racist. So the fact that she acknowledged that the dress code comment was racist. Now you're saying that the company gets to decide on a policy. So was it a racist comment, or did she breach the policy at work that you cannot have African hair?
I would like to further add on to my colleague's comment, and do you not feel that the HR personnel was perpetuating that people of color must conform to Western standards of beauty? Are you saying that natural hair is untidy? Just to add on.
My ladies, we recognize that such comments may come off as racist. Being told that your natural hair is untidy is a comment that might humiliate you. So, in that, we would like to add that a company, if a company has its own dress code policy, and in a company how you present yourself, is important, and how a company chooses the way their employees should look is up to them.
Are you saying you don't see anything wrong with what Ms. Van has said?
My lord, we do see something wrong with what she said. Maybe the delivery came off as racist, and how it was interpreted came off as racist. But what Mrs. Van was doing was she was telling the applicant how employees in the company should present themselves. And when she signed the contract of employment, she was abiding herself to all company policies.
Thank you.
May it please the court, I would like to proceed. C, a fair or refusal to reinstate or re-employ a former employee in terms of prior agreement. Under common law, employees have no legal entitlement to be promoted to post unless they can prove a contractual right or perhaps a legitimate expectation based on some prior promise. This concept was confirmed in the case of Administration, Transvaal and others versus Traub and others. We submit that the applicant had no reason to expect that after the 2 years she spent at the company, she would be reinstated or promoted, as there was no prior agreement. The company is entitled to select who to promote or reinstate based on meeting their requirements. And as I've mentioned, the company mentioned that the reason why they promoted the 3 candidates is because they showed exceptional qualities of being a lawyer. D, occupational detriment other than dismissal in contravention of the Protected Disclosures Act 26 of 2000 on account of the employee having made a protected disclosure. We submit that occupational detriment according to according to the Protected Disclosures Amendment Act 5 of 2000 is defined as follows. And I would like to refer my lords and ladies to, I think, to my last point, to point D that I've made. Because of time, I cannot mention all of them. We're saying, according to the Protected Disclosures Act, Occupational Amendment Act 5 of 2000, occupational detriment as defined as I've mentioned on my argument, and the employee was not subjected to any of the definitions mentioned.
No, I'm not answered. I'm trying to find out because we have done 5 minutes left there. Oh, we still have time.
Okay.
Look, you are bringing in the protected disclosure in the whole matter of unfair discrimination based on gender and race. My question is, what is the relevance of the protected disclosure in this matter?
Can you please repeat?
I'm not saying that you are wrong to raise it. I want to understand so that we are going to be in a position to have a decision on it. What is the relevance of the Protected Disclosure Amendment Act of 2017 in this matter?
It deals with the discrimination of gender and race, as the applicant has mentioned. So we're saying that the applicant was not subjected to any occupational detriment in reporting the harassment that occurred.
But are we? Is that act not dealing with whistleblowers, for instance? Protected disclosures in the workplace?
The act is mentioned in the Labor Relations Act.
Yes.
So, in section 186, subsection 2, that the applicant says the not promoting her amounts to unfair labor practice according to that section.
Yes, but I would understand that the Protected Disclosure Amendment Act will deal with the issues of whistleblowers in the workplace and cannot be relevant to this. You have to convince me on that. I'm not saying you are wrong, but I'm trying to draw that to your attention.
My lord, the reason why we mentioned the Protected Disclosures Act is because it's mentioned in the Labor Relations Act.
Thank you. I think you can say.
We are saying the applicant was not subjected to any of the definitions of occupational detriment that I've mentioned in my argument. May it please the court, I would like to proceed with our prayer.
Thank you.
The respondent asked for justice to prevail and pleads with the court to find the claims of the applicant's claim of harassment, discrimination in terms of the Employment Equity Act 55 of 1998 and the unfair labor practice in terms of the Labor Relations Act 66 of 1995 invalid.
But you and your colleague have made some concession. Not so. A concession that the way Ms. Van addressed the issue might have been gone too far to find that it amounts to discrimination of the applicant. Do you want to have the last bite on that?
My lord, we do recognize that the comments, as I've mentioned, that the comments that were made by the HR lady could be interpreted as racist. She could have told anyone who came into her office with hair that that was not acceptable in the company. She could have told anyone that this hair is not acceptable, so you should cut it. It's just that the person that she told was someone of color, and in saying those comments, it came off as racist.
I'm told 2 minutes left, so we can still engage, colleagues.
Yes, ma'am.
I'm just curious. So you do acknowledge the fact that the comment might have been racist, but you require us to invalidate that discrimination. Because you've prayed for us to regard this unfair practice or this might possibly be racist comment as just a comment that is made while acknowledging that it has been racist. You're asking us to say that it's invalid.
No, my lady.
That is in your prayer. What would you like us to do in terms of, because you have acknowledged that this statement could come off as racist, and Buleng did receive it as racist. So you guys concede to that, but now what are you actually praying for us to do? To maybe consider that it happened, but it was just an oversight?
My lady, we're not asking you to overlook that.
Okay.
We are recognizing that, and that issue would be dealt with the company, by the company.
Also, you'll go back and deal with it at home?
Not really.
Yes, to further add to my colleague's point, how had the employer educated the employees on racial insensitivity and the appropriate conduct in the workplace? How could, it comes off as very offensive when someone in HR is not politically correct when dealing with people of color or anyone in the workplace. Was that not insensitive in the way you did say it? Is it racist, or was it interpreted as racist?
My lady, we recognize that such comments might have come off as racist, and they were in fact racist, and we're not disputing that. But what we are saying is what Mrs. Van meant was not supposed to be racist. It was not supposed to come off as racist, and we're not invalidating the applicant's feelings. We are recognizing them, but what we're saying is the reason why Mrs. Van talked about Hehe was because she was following company policy, which is how the employees are supposed to present themselves.
I'm told that the one. Wouldn't the prayer would have been phrased properly if you are asking us to dismiss the applicant's case?
Yes, my lord.
Because I can see you wanted us to declare invalid, which raises a confusion as to whether you wanted us to declare invalid the section of the Employment Equity Act and the Labor Relations Act, because you can only declare invalid something in the legislation if it's inconsistent either with the constitution of the country. So do I understand your prayer to say you want the applicant's case to be dismissed?
Yes.
Thank you, Councillor. Unless if you have more, apparently it's time up.
Okay.
And thank you very much
Thank you.
for that. I believe I'll be guided by whether the applicant is ready to reply or through my secretary that side, whether there can be a short adjournment. I'll be guided by.
As President the Court, we were told by the applicant that they would like to have a 10-minute short break, then they will be ready to reply after.
Thank you. Then the court will adjourn for 10 minutes. All right. Thank you. Thank you. forget a lot.
Yes, so just leave it on.
So you will have to put that, what is it that we are going to pronounce on it. Then when I pronounce, I'll... All right. Sir, are we going to start now?
Yes, we are about to start. We wanted to ask, all the applicants goes for rebuttals, right?
Yeah.
Our respondents will say that.
No. Normally we call them replies. I don't know in case but you call them rebuttals. They don't have to respond. These ones are the ones that respond to the issue. And we close. And that is where we can reserve our judgment. We come and deliver it. And they will also pronounce on those who have won and those who are not.
Okay. How much time should we give? We should just let them flow.
Which one? This one? Yes. No, for replying, I think 5 minutes is sufficient.
Each or both of them? 5 minutes?
No, 5 minutes will be. This is not for both. Or what do you think? Do you think we have to make replies for more than 5 minutes?
I think 5 is sufficient. 5 for each or 5 for overall?
Or 5, is it?
Yeah.
5 over?
Yeah. Because it's just concluding as you read.
Yes, yes.
So do we have to now write what we think of it?
Yes, I think.
Yeah, at the bottom we'll have to write
But remember as well that not all of them, I mean, the two sides, as I look at them, the other one was given a difficult task because the facts were not favorable. So we must also look as to how did they try to merge their, yes, because the determining factor should not about whether the other one, the facts were favorable. It should be as to how they were able to argue their facts, even when it was difficult to do so.
Rise in court. The University of KwaZulu-Natal court is now in session. Thank you.
Counsel for the applicant now, it's your turn to reply. I'm told here in KZN you use the rebuttal. It's your turn, applicant.
Thank you, Justice. Now, Justices, we have 3 points to raise on our rebuttals. First, the respondent's submissions that they are not vicariously liable based on the argument that the commission that is in question is out of employment employment practices. The second point that we put on our rebuttals is that employers, as the respondents are, has a discretion to determine their merits to whom to promote and to whom to demote. The last point that we will deal with is the point that the respondents argue that they have taken fair measures to deal with the harassment based on the race of race, the first commission. I will deal with the first point. The respondents indicated that the harassment in question happened out of the merits of employment practices. I would like to refer the court to the bigger case. In this case, it was held that it need not to be within the employment practices. Even if there is employment relationship, it is valid to indicate that there is harassment. In this case, Justices, just to illustrate how the court approached its submission, its decision, the applicant in this case was subjected to harassment on the basis of race, as the other employee indicated that they used racist remarks out of the employment practices, but the remarks were indicated in a commune which was provided for by the employees for its by the employer for its employees. Then, as the employees were within one commune which was provided for by the employer, the employment relationship was instituted by the employer. Thus, the court indicated that the harassment take its course within the premises of employment practices, as the employment relationship between the employees was instituted by the employer. In this case, our applicant and the other employee which has stated the harassing statement were employed by Men-A-IT, and there is no other relationship between the two, as they only relate in terms of the employment relationship they have. They linked with in the digital platform as a result of their employment. If our applicant was not employed by Men-A-IT, there would have been no relationship between Puleng and Bulelani, who has instituted the statement. Then we submit that the harassment has occurred within the employment practices, as the employment relationship between the applicant and Bulelani was instituted as a result of the employment by Men-A-IT. Secondly, one deals with the second argument that was indicated by the respondents, that the respondents have discretion to determine their merits, to determine whom to promote and whom to demote. In this case, counsel relies on the case of Mofokeng, which is indicated under page 16. In this case, it was indicated that the employers are authorized to determine their merits to whom to promote or not. However, their criteria should be procedurally fair and subjectively fair. In this case, we submit that the subjective fairness was not fulfilled by the employer's criteria, as the HR or the manager has indicated that for our applicant to be promoted, she should cut his hair and be improve her image for being a professional. Thus, we submit that the reason for not promoting our applicant is not based on the merits that she has no qualifications or other experience, because our applicant has practiced the minutes that were indicated by the respondent.
Are you not bringing new evidence before us?
Justices, I'm responding to the argument that was indicated that we did not deal with on our heads of argument, as we heard of it during the course of the respondent submissions.
Thank you.
Thank you, Justices. In this case, as it was indicated, that the merits to determine whom to promote or not should be based on fairness, subjectivity, and procedural fairness. In this case, the criteria determined by the employer is not subjectively fair, as the rationale behind not promoting our applicant is based on harassment, which is unfairly discriminating our applicant. Thank you, Justice. Yes, Justice.
No, I don't have a question. Are you done?
Yeah, I'm done. If the court pleases, my co-counsel will continue with the last point that you indicated.
I was told that we have 5 minutes on this, and you'll be given 2 minutes to wrap up.
Thank you, Justice.
Thank you.
Yeah, thank you, Justice.
Justices, lastly, on subjective fairness, I would like to give more details that as the employer's representative, the HR manager harassed the applicant on the ground of race. Thus, the applicant is not promoted as she did not submit to the racial instruction to cut her hair untidy. Therefore, the counsel submits the employer's omission to not to promote is subjective, unfair, as the rationale of the employer's decision not to promote the applicant is inspired by unfair discrimination on the ground of gender. Therefore, I would like to, as the counsels for the applicants would like to in court order that's the employer's failure to promote the applicant to be unfair labor practice. Thank you.
Thank you, counsels. And we would like to thank you for your presentation, all of you. We would like to have some few seconds upon which we will be in a position to decide on this matter. And may I request that at least this court adjourn for at least some 5 minutes, on which the court will be in a position to reflect. Therefore, the judgment will be reserved for that 4 minutes or 5 minutes. Thank you.
Rise in court.
You must be careful of not asking for permission to change in my court. Ladies and gentlemen, may we proceed?
Well, it has been a long journey, a very interesting one, mind stimulating. And you know, when you are attending things like this, you learn a lot. Not only as per your academic areas, but also in real life situations. So we really appreciate everyone for coming here. I'm not doing votes of thanks though, no way. But our judges now, they have arrived to a stage whereby they don't just want to have a talk with us. Thank you.
Thank you, councillors. I hope all of you are prepared to get the judgment. I'm going to hand this extempore, and I'm going to be short. I will not be going into the details too much. Those who will want a written judgment, then you are free to ask for it thereafter. I understand the applicant brought an application before the Labour Court after there was a conciliation in respect of the unfair discrimination in terms of Section 6 of the Employment Equity Act. This can be read with the Labour Relations Act. For one, declaration that the conduct of the respondent being a company duly registered in terms of the laws of the country should be found vicariously liable on the basis that its employees conducted themselves in such a way that offended the principles and the rights of the applicant as enshrined in both Section 6 of the Employment Equity Act as well as Section 9 of the Constitution of this country. I will not go into repeat the facts before us, but in summary, the facts are as follows. Puleng was employed by the respondents, being men R8, as one of the lawyers who graduated from both the KwaZulu-Natal University and the Harvard Law School in the United States of America. When she was employed, the employer, in most occasions, when there were heavy meetings, she used to be a scriber, and she was even referred in Zulu that she was Usesi Wamaminets. However, in my judgment, I'm not going to deal much with the fact whether she was called Usesi Wamaminets, because that was not challenged. It was brought to this court as a remark. Therefore, the period upon which the unfair labor practice could have instituted, I believe is 90 days, which in this matter might have passed. So I'm not going to decide on that matter. The issues that are before me are two issues. Whether the conduct of the respondents, being the employer in this case, constitute unfair discrimination. And that invite me to go straight to Section 6, which reads as follows. No person may unfairly discriminate directly or indirectly against an employee in any employment policy or practice on one or more grounds, including race, gender, sex, pregnancy, marital status, family responsibility, ethnicity or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, and birth. Now, it is very clear before this court that the discrimination is based on listed ground, which is covered by Section 6(1) of the Employment Equity. And it is not only that, there is an issue of harassment. Section 6(3) of the Employment Equity read as follows. Harassment of the employee is a form of unfair discrimination and is prohibited on any one or combination of grounds of unfair discrimination listed in subsection 1. And Section 6, subsection 2 read as follows. It is not unfair discrimination to take affirmative measures consistent with the purpose of this act or distinguish, exclude, or prefer any person on the basis of inherent requirements of the job. I understand counsel for the respondents, even though she did not specifically refer to this section. Her defense was based on that in respect of the unfair labor practice relating to promotion. However, her point was genuine and was honest. Whether the point fit within the requirements as is in this case is another issue. The employer, senior personnel, was tolerated when he had to tell the applicant about his, hairdressing code, and the employer did not do anything with that. And there was no policy that was presented before this court as to how people should dress. And even if there was such policy, there is no evidence that such policy would have passed the constitutional requirement. It is a well-known fact that women are marginalized, and they've been marginalized throughout in all areas of life around the world. And it is a well-known fact that there are some legislation that were promulgated to protect them, and the employment equity being one of them, and the Constitution being one of them. And obviously, when now we are faced with matters of this nature, we should take cognizance of the preamble of the Constitutions, which was also to protect those who were marginalized. Now the question comes, if the applicant is one of those who are marginalized, does she have to automatically be entitled to the relief that is before us? The answer will be probably no. But the second question will be, under these circumstances, did the applicant prove that indeed she was subjected to some conducts that amounts to unfair discrimination? The answer will be probably yes. And under those circumstances, the third question can also, if you have to measure the unfair discrimination, whether there was any differentiation, you could see she was even called Usesiwama minutes. But that differentiation, I don't believe it amounted to discrimination. But however, at the time now, when she has to be told to cut her hair, that was the time now that she's exposed to the discrimination that is prohibited in terms of both Section 6 and Section 9 of the Constitution. It is common cause that blacks, they might be having born differently with different hairs. And obviously, the moment you start to tell them how their hair should look like, you are also having to entertain things that has to do with their origin, which you will never have control of. And this is done to a woman, the woman that has been marginalized from the beginning. Therefore, I found that the conduct of Ms. Van amounted to unfair discrimination. Now that brings me to the issue of the unfair labor practice in respect of the promotion. I don't have evidence before me that has to show that there was a criteria that was used to promote the four men. In terms of the law, both in the Labor Relations Act, there are some criteria that are set by employees in respect of measuring who can be promoted or not be promoted. It cannot be a coincidence that the applicant, being the only woman who's employed with this man, that she find herself not being promoted. And it can be a coincidence that the statement of Ms. Van, which speaks about professionalism, that has to go with the dressing code, is equally argued by the respondents' councils as a measure that they have used to determine whether there was a promotion. Then thus tells the court that the respondents actually did not have a criteria. They were influenced as well by what might have happened on the social media, on the issue of the dressing code that has nothing to do with the promotion. I therefore also find that there was no merit in what the respondents was defending. However, the respondents' counsel was faced with such a situation wherein it was very clear that the effects were very difficult to defend. But however, having tried to show this court that indeed it was not out of their will to discriminate this, but they failed to show this court what measures they took, including the measures that would have been taken against Ms. Van. They failed to tell this court when they knew, because there was concession from the council of the respondents, that indeed they noticed that there was discrimination. But actually what they want from this court is to say, we are sorry, but you don't have to do anything to us, which really is unfair. Therefore, that brings me, having considered and read your papers, and having looked at the cases that you have presented before us, to make an order as follows. The respondents committed unfair discrimination. And the declaration of the conduct of the senior partner and HR, Ms. Van, which amount to unfair discrimination based on gender and race, is therefore granted. That Ms. Van is ordered to apologize to the applicant for the utterances of racial comments that she has made. That the respondent is ordered to pay the applicant 24 months salary for being in contravention of the Employment Equity Act. That the senior member of the applicant, being Bulelani, is ordered to withdraw the statement of the social media being linked and make an official apology to the applicant. And that the respondents has to implement a better code of conduct and no order as to cause. I therefore hand down the judgment. The applicant, when I hand down the judgment, you stand up and tell me that as it pleases the court, even if it is not pleasing you. The respondents, you also stand up and tell me that as it pleases the court, even if it's not pleasing you. Can you do that, applicants?
As it pleases the court.
Thank you, Counsel.
As it pleases the court.
Thank you. Before you could get your pronouncement of your results, I would like to thank all the counsels that has presented the case. Losing a case does not mean that you are not a good counsel. It means that the facts that you are presenting might not have been good for you. And I therefore would like to thank all of you for for having been so strong and adamant. Some of the questions we were asking them intentionally. Why do we know that the answer will be difficult? Because the purpose of doing that was to see whether you can think on your feet and be able to answer those questions. And I will therefore hand this to my colleagues as well. I can't be a man that has been speaking for a long time while I am surrounded by women. Thank you.
Thank you so much to my colleague. Thank you so much to our presenters. So I think at this stage of the proceedings, we're about to hand over to the winners. Obviously, while everything was so beautifully done, there is always one winner as it stands. So I would like to first and foremost thank you guys, the BLA student chapter, for giving us this session, to see our students do the things that they only get to do in practice or once in their L&B degree, really, when they meet it in final year. So to see you guys participate, take your time, try to answer these really difficult questions, and the analysis of the law that you've done, it really is really good work, and we really appreciate seeing the effort that you have done or you have put in to participate in this. It's very wonderful. I'm also found it interesting for the organizers to put the ladies this side and to put the gentlemen this side. It's very interesting to be put in a position where, you might find yourself, and you are African ladies, you might find yourself in that position. And at this point in our lives, we're afraid to either be too obvious about who we are, about our blackness. And so when we're put in a position where we have to use the law that was designed to oppress us, that was designed to make sure that we still stay small, and you have to rise above that and use that very law, I can understand how challenging it is, but these are the things that we are obviously trying to deal with at this moment. We are trying to find ourselves in a position to dress the way that we feel comfortable in and still be understood to deliver the utmost kind of legal proceedings, just like any other man, just like any other color person. So it was very interesting, and I am very impressed with your work. Either way, even if you didn't win the judgment. So we are very grateful for this, and we would like to see more of it. We would definitely like to see more of it, more women involved. I'm not discriminating against the gentleman. I think you did a very good job in standing up for women, because at the end of the day, the one thing that we do need, outside of having to always stand up for ourselves, is the counterparts of the men that we stand next to be able to defend us in situations where it seems really tricky. So with that said, I don't know if we need to stand up to give our winners and be able to announce who will be taking all these wonderful trophies that we have here. All right. Okay, so I believe we have some awards that have already got their names on them, so I'm not sure how we're going to do it. I feel like I remember they wanted to take pictures. So how do we line this up? Do we come in front? Do we stand in the middle here? We'll need this. Can I get a mic? Yeah. Can I get a mic? Can I get a mic? Yeah, there you are.
please.
Okay. So, firstly, we did receive the heads of arguments, and we did receive the written arguments. So, the winners for that goes to, or the best legal opinion that we have received goes to Kwandile Matebula. Thank you so much.
Can we take a picture?
Oh. Okay. Oh, we also have your certificate of participation, Wandile. So please pass me all that trophy. Yes, you can. All right. Well, Wandile obviously didn't work alone in his legal opinion, so the other best legal opinionist had to be Roberto Brown. Okay, so we. So, if there's a winner, there's always obviously going to be a runner-up. So, in this situation, our runner-up team, for a really great job, under the circumstances, will go to our respondents, Ms. Sandisile and Mbali. Can you come this way? So many runner-up. How many runner-up teams are there? Oh, for both of them. Okay. Yes. Well, congratulations, my dear. That was well done. Definitely have your own trophy. Certificates as well. Someone forgot her name. Okay, and obviously then that leaves us with the first place when it comes to your whole argument. So our winners would be the appellant's team, that is Roberto and Gwandile. Congratulations, gentlemen. You did win the order. On behalf of the ladies, thank you again. Yeah. Congratulations. Well done. So there is one final prize. This one final prize is to, obviously, out of the whole lot of you, appreciate your conversation skills, your conciseness, your confidence, and be really, really, really grateful that you all stood here in front of the cameras, in front of us esteemed judges, and were able to present your case as nervous as you were. But obviously there is one person who maintained or was able to maintain their composure and make sure that they give us judges the ability to say that there is one person who did come out at the top of this game, you know, even though everybody was really, really, really brilliant. So for this reason, we have the final one, which is the best oralist, and the best oralist for today's Moot competition goes to Roberto Brown. Thank you so much.
I'm not sure whether to say she's the chairperson for the Black Lawyers Association Student Chapter from Pietermaritzburg campus, or I should say she's an outgoing one. I don't know. She'll tell us. She's here. Thank you.
Good afternoon to everybody. All protocol observed. So my name is Nompendulo Tsaile. As he has said, I also don't know how to introduce myself. I don't know to say I am the chairperson, I am the deputy president of the National Executive for 2022 or 2023. So I've been tasked with something small, but yet so important, just to say thank you. So I've written a list down so I do not forget anyone. So firstly, let me just start by thanking the university for allowing us to use their venues, administer laws to us as a student chapter. Secondly, let me thank the College of Law and Management, starting with the PR team of Sis Thandi Jumo with her team. You know, when Sis Thandi came to us, I think it was March, and she said she wanted to do a project with BLA. And I was thinking, how is this going to work? And then she had done an article about us for those who may have seen it. And then she said she wanted something to show the skills of law students. And then we came up with the idea of a Moot. So without her, we wouldn't have been able to pull this off at all. We thank you, Sis Sandia, for being patient with us. We know we are hard to work with sometimes. Thank you so much with you and your entire crew for making sure we even appear on YouTube without any glitches whatsoever. Thank you so much. And then I want to say thank you to the person who actually created this hypothetical case, Dr. Myongani from the School of Law. Thank you so much for being on the journey with us and making sure that this event is a success. Even though you're not here, I know he's not around, he's live streaming somewhere, but thank you very much. And also to other School of Law academics, Ms. Priya Singh, Dr. Kulegani Kumalo, Nikki Whitnell, Robin, thank you so much for supporting us and making sure we had the support we needed to pull off this event. It means a lot to us. And then I would love to thank SGLD, which is Student Governance Leadership and Development from Pietermaritzburg campus. That is Mr. Bektemba Dlamini with his team, Ms. Angel Ndlovu, for ensuring that we have refreshments for today and also ensuring that we are able to come from Pietermaritzburg here to Durban because they provided transport for us. So thank you very much. And then I would love to thank, I don't know whether to say mother body, father body, but to our NEC, which is the National Executive of Black Lawyers Association. Thank you for making it through. And you can see one of them is actually one of our judges. So thank you to our judges also. And also thank you to somebody who I would like to thank in his personal capacity from Shefston and Wiley, Mr. Msomi. Thank you for making sure we have these beautiful awards to present to our participants today. Thank you very much. And then I would love to thank the PEC, which is the PEC actually of KwaZulu-Natal of the mother body. I can see one of their representatives, Ms. Wenzile, who's actually the head of education for our province, for always ensuring that we got the support that we needed, ensuring that the banners arrive on time. Thank you again for that. And then I would love to thank the panel. I know there were things that were short notice, but we were able to pull through, so thank you so much for that, and actually making sure that we pull off this event. Thank you. And then I would love to thank the participants. Now, for those who do not know, actually our participants are not 4th years, they're actually 2nd years and 3rd years. It is 2nd years and 3rd years. So the aim of this competition in the first place was to equip 2nd years and 3rd years with skills so that when they go to 4th year for their moods that they have as a module, they are fully prepared. Because the moods that you do at 4th year, they're very hard. And when you're doing something for the first time and it's your final year, it's very challenging. So I was like, they should have a chance to do it earlier just to prepare them. Because we don't have practicals at School of Law, it's only that mood module at the end of the year. And then I would love to thank the audience, the people who came to watch us, and the audience at home, those who are streaming. Thank you, guys. And then lastly, the people I wanted to thank lastly, and that is my BEC. As your outgoing chairperson, I'm very proud. I am very proud. We've worked well together for the past 8 months. There's been challenges, of course. There are always going to be challenges when you're working with people, but you guys have been truly, truly amazing in ensuring that we're able to pull off every event that's been there. From the deputy chairperson down to your legal and research officer, to everyone who is in my BEC, thank you so much. And actually helping me, allowing me actually to lead you as your chairperson. So now I'm going to hand over the branch to Mr. Ngema, and I hope you'll give him the same respect that you have given me. Thank you very much, everybody.
Wow. Wow. This was amazing. I'm getting emotional. This is very amazing. It is, it will be amazing. And to always start a journey whereby you know that in future when you look back, this is where you'll say, that's where we started. It's amazing. And we know that our judges, one of our judges did mention that we need new laws. We are not living in an apartheid time now. We are the ones who can bring change. So, like it or not, ready or not, we better be ready. Now I'm being told by someone who has ambushed me that there are refreshments that are waiting for us. Let us meet them and see. Thank you.
I had to take this platform. I'm not built to say anything, but I couldn't just keep quiet. Just 3 observations that I wanted to make. One observation is that in that young lady, Nompendulo Cele, who was here, you have a great leader. Very persistent. She sends you WhatsApp messages. She sends you email messages. She's literally on your case. And well done, Nompendulo. Congratulations again for assuming the deputy presidency of our student chapter. We wish you all the best. We hope you'll take the student chapter to another level. So that is one point I wanted to make. The second point I wanted to make is that the case that was argued today reminded me of a research that was done by the Wits University. around what actually happens in different workplaces, around how women lawyers are treated. And I'm going to encourage all of you to read that document, because that document is going to prepare you for the road that lies ahead. It talks almost exactly to what was being discussed today. There, though the research was not about minute-taking, it was about softer things that happen when there is client consultations. A woman lawyer is expected to make tea for colleagues, to serve tea for colleagues and clients. So I would urge you to read that document so that you can be prepared about what happens when you leave the profession. On that note, I was not asked to say a word, but I simply could not keep quiet and not say something, because it's just in my nature. These kids here who have argued today, looking back, I was here from 1990 to 1994. Probably it was before they were born. Going back to whether I would have been able in my second year to put up brilliant arguments that they put up today, I don't think so. So you guys have done well. I was saying to my colleagues there that you have really begun to shape your own CVs. Because when you start applying for employment, there must be that distinguishing feature that makes you different from another candidate. Law students are being churned out in huge numbers, and there's just simply not enough space to accommodate all of you. It saddens us when we receive applications and you can only take so much or so many of students. What does that mean? It means the space out there is highly competitive. So if the space out there is highly competitive, what it means is that you must be a cut above the rest. And it starts here. It starts with what you have done today. You have trophies already, you have certificates already, your CV is beginning to take shape, is being decorated in a manner that is going to distinguish you from other candidates when you go out for interviews, looking for articles, and whatever form of employment that you'll be looking for. With those few words, my deepest apologies for hijacking your program, but I couldn't keep quiet. Thank you so much.